And we're back. We're going to jump right into Gamble v. United States. It's kind of an odd slide to begin with, don't you think, Lance?
Yeah, it's a bit of a gamble.
A T-shirt. Oh, I thought we should do that. It has 2 gold coins on it.
Yeah.
Do you know what this case
is there some
about?
significance to those gold coins?
There actually
Are they
is.
doubloons?
They're not doubloons. They're sovereigns.
Oh.
And there's 2 of them.
Would that make it dual sovereignty?
They would make it a dual sovereignty.
Oh, man.
Yeah,
Classic.
Yeah, you're welcome. So this is about a case about dual sovereignty. Think all the way back to law school. The question in this case is the dual sovereignty doctrine still a thing that exists? The answer is yes. So this is most noteworthy for what it didn't do. It just affirmed something that's been around for a few hundred years at least. Right? All right, this is Terrence Gamble. He was stopped by police in Mobile, Alabama for driving a car with a damaged headlight. So during the stop, the officer smelled some weed. Later, yada, 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 searched the car, found a loaded 9mm handgun, which might not be as much of an issue, but unfortunately for Mr. Gamble, he'd previously been convicted of a second-degree felony. So under Alabama firearm laws, he was a restricted person, right? As he would be in, I think, just about any other jurisdiction. So here's Alabama Code, Section 13A 1172, pretty standard felon in possession statute. Gamble pled guilty, did you see? Pled guilty and was given a year in jail and probation in state court. Now it's Uncle Sam's turn. So here is 18 U.S.C. 922 G1. This is the federal felon in possession statute. Every gun that has moved in or is affected interstate commerce. Same offense, essentially, with the exception of the interstate commerce element. Gamble moved to dismiss on double jeopardy grounds, and the district court, once he's in federal court, denied the motion, and he entered into a conditional guilty plea, what we often call Siri pleas in Utah, or now Rule, I think 11J pleas. It's been put in the rules of appellate procedure. He reserved his right to appeal. The 11th Circuit affirmed based on the dual sovereignty doctrine, and the Supreme Court granted cert. And this is what really got people's attention, because there was the conventional wisdom with granting certiorari review is that you don't grant review to affirm. The Supreme Court usually grants review because the lower court got it wrong, or they're on the wrong side of a split. So when they granted review in this case, the thinking was great. At least 4 members of the court are inclined to review the dual sovereignty doctrine and possibly get rid of it. So this got a lot of people's attention. And it ended up being nothing. It was a 7-2 vote, Alito writing, and basically saying the dual sovereignty doctrine still exists and is valid. So we'll start with the text here. No person shall be subject for the same offense to be put twice in jeopardy of life or limb. Oh, that's actually the same offense, not the same offense, but you get the idea.
Very nice.
Yeah. This is an argument almost as old as the double jeopardy clause itself. So it protects from retrial from the same offense, not for the same conduct. And offenses have been defined for a very long time as once per sovereign. And as we know, we have 2 sovereigns in the United States. We have the state governments and we have the federal governments that each have their own independent interests, the idea runs, in ensuring public safety, in exercising prosecutorial discretion, all that sort of thing. So when there are separate sovereigns, there are separate offenses, or if you want to think about it, separate teams, even if they're running the same play, those are different offenses, right? So Gamble pointed to the drafting history of the Fifth Amendment, and this is really what his entire argument hinged on. So way back when they were debating the Bill of Rights, we have Mr. Partridge here moving to insert after same offense the words by any law of the United States. So, and that amendment failed. And Gamble said that omission means something because Congress or the people could have limited double jeopardy only to federal prosecutions. That is to say, it only applies in federal court, not in state court, but it didn't. And in the first congressional Congress, this Representative Partridge proposed this and it wasn't adopted. So he said, Gamble said, this supports my view that the framers did not agree with the dual sovereignty doctrine because had they agreed with it, they would have adopted this language. And the court really wasn't impressed with that. They said, quote, the private intent behind a drafter's rejection of one version of a text is shoddy evidence of the public meaning of an altogether different text. So that wasn't going to get him anywhere. But he wasn't done. So he flips the argument. Alito actually flips the argument on Mr. Gamble and says, actually, let's look at the Declaration of Independence. One of the complaints of the signers was that King George was using the practice of trying in England under British law English soldiers who killed colonists in America. So think way back to the Boston Massacre, right? The Boston Massacre trial actually happened here in the colonies in Massachusetts, and John Adams was the defense attorney, right? Very famous trial. The king did not like the idea of having British soldiers who were often not well liked by the locals, at least a significant portion of the locals. I think the historical estimates tend to run around 1/3 of the population were pretty ardent patriots. A third were ardent loyalists, and a third were just going to kind of stick around and see who won. But when you had people like Samuel Adams in Boston, who were very ardent and very active in their seeking to undermine British authority and assert colonial authority, local authority over colonial governments, the king essentially thought, maybe not without reason, that British soldiers would not get a fair trial if they were tried in the colonies. So he would ship defendants back to England to be tried there. And that was something that in the Declaration of Independence was one of the list of complaints. So after the Boston Massacre, the British Parliament passed what came to be known as the Murderers Act, which might be one of the coolest act names in all of history. We don't have those anymore. It's, it's like the Affordable Care Act or whatever else. We don't have many Murderers Acts anymore. So this basically took control away from local juries, which caused a lot of anger here in the colonies. And in a way, when you think about it, the Declaration, this is a little bit of an aside, but if you've ever read it, most of us read the preamble in school and don't get very far beyond that. But it's basically just an airing of grievances. So really, the 4th of July was the first Festivus. That's how I like to think about it.
That's why we always have a feat of strength in our house.
Oh, exactly. Or it's not, you have to go through Dad to get to the barbecue,
Exactly.
or you're not going to eat it. So Justice Alito looked at that and said, on Gamble's reading, the same founders who quite literally revolted against the use of acquittals abroad to bar criminal prosecutions here would soon give us an amendment allowing foreign acquittals to spare domestic criminals. We doubt it. Yeah. So the historical evidence was not as strong as Gamble thought it might be. And yeah, I think that qualifies. We don't have a lot of gotcha moments in appeals. It's a pretty scholastic pursuit. It's very academic, but Gamble might want to apply some water to that sick burn. That's a pretty good one from Justice Alito. So let's look at some of the history on the dual sovereignty doctrine. A lot of cases from the mid-19th century, and the court pointed to these and said, our interpretation of the clause is not barring, if something happens abroad, because that's what he was claiming. He was saying that the founders, there was this kind of common law thing that we'll get to shortly, that sometimes if you were convicted in Portugal of something and then you came back to England, maybe that previous prosecution in Portugal would bar retrial in England. And we'll see how Justice Alito deals with that. But he says, let's look at these 3 pre-Civil War cases. They fleshed out the idea that state and federal criminal laws promote separate but equally important interests. Fox v. Ohio. Fox was charged in state court for counterfeiting and passing a counterfeit coin. And she claimed that the Constitution conferred sole authority over counterfeiting to the U.S. government, because that's one of the things listed in Article 1, right? Congress has the power to coin money. The court said, no, the states can criminalize fraud and the passing of the money, notwithstanding Congress's power to coin money. So again, same kind of offense, but different interests involved. Marigold was the other side of the coin, badum-ching. See that?
Nice.
Federal prosecution for counterfeiting. And they said, well, the state's ability to criminalize in Fox didn't mean the federal government could not. So the federal government could literally pass the same exact statute as a state or criminalize the same activity, and there are still different sovereign interests to vindicate there. And finally, Moore v. Illinois. Moore involved state and federal fugitive slave laws, and talked about, it gave as an analogy assaulting a U.S. Marshal. So if you assault a U.S. Marshal for the federal government, the interest is you're interrupting the functioning of the federal government. An officer of the federal government, you're interfering with legal process. For the state, that's a breach of the peace, right? That's a battery, that's an assault, however state common law defined it at the time. They're both okay because each person is a citizen both of the state and of the United States and is liable to both for breaches of their laws. So again, the court says we're not really treading on any new ground here. This has been around a very long time. The court also analogized to modern international law. This just kind of seems like piling on at this point, right? They've got text, they've got history, they've got common sense, they've got prior cases, but Alito keeps going. He said, in modern international law, if somebody has murdered a U.S. citizen in a foreign country, they can be prosecuted both in the foreign country and in the United States. And again, think about the different sovereign interests. For the United States, it's the loss of the life of one of our citizens. For the other country where their life was taken, it's a breach of their peace. You know, that's not good for business. If it's a tourist destination and somebody gets killed, that's bad for them. They have an interest in preventing that sort of thing from happening. So we'll finish up here with talking about the common law. So interestingly enough, the common law comes from the time of just before Robin Hood was set. So King Henry II was the father to both John and Richard, and he decided that he wanted to exert more control over what at the time had been a lot of local customary law. So if you committed something that would have been a crime, you steal something, you punch somebody way back when in the 13th century, then you were judged according to local custom. And King Henry said, no, we need a common law, a law that applies everywhere to all citizens of the realm. And by the way, instead of just finding somebody locally who can resolve your dispute, you need to come to a royal court if you want something done. So that's where we get the common law, interestingly enough. That's just a little aside. But the court said, look, if we look at the common law, basically everything that happened from the reign of King Henry II up to the time of the founding, from the very dawn of the common law in medieval England until the adoption of the Fifth Amendment in 1971, the court says, there is not one reported decision barring a prosecution based on a prior trial under foreign law. So again, there's just no there. And what Gamble pointed to is something called the Hutchinson cases. These go back to the mid to late 1600s. It actually goes back to Rex v. Thomas, but if you look at Hutchinson, it's a very brief opinion. It appears to be the report of a bail hearing. So it seems like Hutchinson was an English citizen who was tried in murder for Portugal or maybe Spain, and then he was acquitted there. And he returned to England and was tried there. And because he had been tried and acquitted for a murder in Portugal, he was denied bail. And that's essentially what the case says. I went back and read it. It's actually kind of interesting. But for whatever reason, jurists for decades after Hutchinson discussed the case as if it is authority for the proposition that you can't try an English citizen for a murder that happened abroad and that he was already tried on. And then its legend kind of built from there. So one court picked up on it and cited it for a proposition it didn't stand for, and then every other case that came after it kept citing it. And he was saying, well, Gamble was basically saying, by the time the Fifth Amendment came around, we have all of these cases stacked on each other. Even if they were based on a misunderstanding, that's what everybody would have understood. So this mistake became the law, essentially. And he said, so even if the cases are kind of muddy, the treatises were very clear. And this is, so he was basically saying, even though it was originally a mistake, it then became the law. And I love this next line. This is a curious argument indeed. It would have us hold that the Fifth Amendment codified a common law right that existed in legend, not in case law. Those are some famous legends down there. You know, the Loch Ness Monster and Bigfoot and John.
Rule 3.
Yes, exactly. So essentially in the battle between legend and stare decisis wins, and the court ends with this. Look, we have centuries of case law saying that this is okay, and a few arguable legends in the common law are not going to convince us to change course now. So affirmed.
Is it stare decisis? I don't want to keep nitpicking on words here, but I always heard stare decisis. Is it stare?
It's anything you want it to be. Latin is a dead language. It's probably stare decisis because there is no S sound for C's in Latin.
And the fact that you know that.
Yeah, I've studied Latin.
Okay. Well, thank you. Appreciate that. So, we live in interesting times. They're troubled times, but they're also kind of magical times sometimes. Those of you who have seen John Krasinski's podcast may have seen the episode in which there was a young girl who wanted nothing more than to see Hamilton, and because of the pandemic, she wasn't able to do so. And so John Krasinski was able to basically get the entire cast of Hamilton to get together and create a Zoom kind of montage of them singing an entire song with like 20 different people all participating, singing their various parts. I was also able to get a hold of the cast of Hamilton and have them just tweak one of their songs a little bit to kind of fit what's happening in this case. So I'm going to share it with you. Listen closely, and I subtitled it at the bottom because it's a little bit hard to follow because it's, fast and rappy.
I am not throwing away my shot. I am not throwing away my shot. I'm just like my country. I'm young, scrappy, and hungry, and I'm not throwing away my shot. I'ma take the phenamine from this bottle. I probably shouldn't steal, but for real, there's a lot'll. Anybody notice if I take a couple pills? After all, I got the bad chills, it'll fix all the ills. I'm a pharmacist by trade, getting well paid, but it doesn't mean that greed can fill that old never-ending need. Only 44, but my mind is older. These Salt Lake City streets get colder. I shoulder every burden, every disadvantage I've learned to manage. I don't have a gun to brandish, I walk these streets famished. The plan is to crush these pills and put them in my veins, but the getting wise gotta excise what remains.
So that was kind of them. We appreciated that for our presentation today. Stacey Hamilton is a case about a pharmacist. And the question here is basically, are what appear to be inconsistent verdicts a basis to overturn the one charge that did actually result in a conviction? And the answer, 9. Okay. The other issue, he also questions the sufficiency of the evidence on an obstruction charge that he was also given. So, as I said, he was a pharmacist. He had 2 technicians that worked for him, and then there was another pharmacist that also worked in that pharmacy. Phentermine is the drug of choice here, the drug that's at issue in this case. It's something that they didn't prescribe very often. In fact, they only had one person to whom they prescribed it out of that pharmacy in a particular dosage. And I thought, interestingly enough, looks a lot like blue peppermint icebreakers. So maybe he just was confused about what was happening. But anyway.
Some expensive preference.
I know, right? One of the techs noticed at some point when she pulled some of the phentermine out to fill a prescription that there appeared to be less than what she would have expected based on their records. Concerned about this, she went and spoke to the other pharmacist, indicated what was going on. The other pharmacist did a little digging, and they started suspecting that maybe Dr. Hamilton was the one who was taking these pills. So they went ahead and reported it up the chain to corporate, who sent an investigator to look into the situation. The investigator dug into the records, found that Dr. Hamilton's credentials had been used to actually change the numbers in the records a couple of different times to reflect what was actually there as opposed to what should have been there. There was also some surveillance footage that showed Dr. Hamilton going into a portion of the pharmacy where the phentermine was, and that he had no reason to be there at that time because he wasn't filling that prescription or anything else that was in that area. So they called him in for a meeting, the investigator did. But as soon as he kind of started talking about what the issue was and what they were there for, Dr. Hamilton got up and walked out of the meeting. At trial, that investigator testified that sometimes discrepancies happen. Sometimes there's a miscalculation, or sometimes the numbers just get off for one reason or another. And so the pharmacists who work in the pharmacy have the ability, with their credentials, to fix issues with the tally for the pills. But anytime they do so, they have to create a record that goes up to corporate so that that can be monitored, and it's not just happening without anyone knowing about it. He testified that Dr. Hamilton's credentials had been used on a number of different occasions to change the number of phentermine pills that they were supposed to have in stock, but that on none of those occasions was a report ever made and given to corporate. So, Dr. Hamilton was convicted of obstruction. He had also been charged with theft and possession of a controlled substance. He was acquitted on both of those counts, so the obstruction was the only conviction. After trial, Dr. Hamilton moved to arrest judgment, saying that those three charges were so inextricably intertwined in that he couldn't very well have obstructed had he not also committed the theft and the possession. And the fact that the jury convicted him of those two things or acquitted him of those two things and convicted him of the obstruction didn't make any sense. It was inconsistent, and that the court should arrest. The district court declined to do so. The court, in its ruling, basically said as long as there was sufficient evidence to support the obstruction conviction, which there was, then we don't think there's any reason to tie the various convictions together. And so his motion was denied at that level. On appeal, and this is Judge Kate Appleby with our Court of Appeals. Oh, that's not Judge Appleby. That's actually Billy Piper from Penny Dreadful and Secret Diary of a Call Girl. That's Judge Appleby. Dr. Hamilton, on appeal, argues that the verdicts were inconsistent, the same argument that he made in his motion to arrest judgment. The court, in indicating what the analysis would be, said they will not reverse unless reasonable minds could not have arrived at the verdict at which they arrived. And as long as there is sufficient evidence to support whatever crimes they convicted him of, then they're not going to disturb the verdict. She also explained that obstruction does not require a person to obstruct relative to their own offenses or their own crimes. And kind of giving him the benefit of the doubt, she says here, or giving the jury the benefit of the doubt, I guess, they says maybe they found that he obstructed a crime that potentially somebody else committed. They also said, or she also said, and this was interesting to me, they may also have compromised or exercised some lenity, which you don't necessarily, I feel like our appellate courts don't often acknowledge the fact that a jury might compromise or split the baby a little bit, but she acknowledged that that may have happened, and apparently she doesn't take issue with it. In any event, she says, even if the verdicts are inconsistent, the issue here is sufficiency of the evidence. And only if there's insufficient evidence is he going to be entitled to relief. Her ultimate holding was that there was sufficient evidence. Therefore, the acquittals on the two charges do not undermine the conviction on the one charge, and the conviction is affirmed.
Yeah, we see more and more of these inconsistent verdict arguments. I'm writing a brief right now where I'm trying to convince the court. Juries really do this. They nullify sometimes. They compromise just because they're sick of deliberating. They decide to cut somebody a break, whatever reason. All the reasons and strange non-reasons that juries do or don't do things. You can't always tell what's going on, even though sometimes it seems pretty apparent how they got to a verdict. That's not something that courts should be looking into. So we'll see how that goes, but we're working on it at appeals to try to educate them on that. Mitchell v. Wisconsin, this is a case about warrantless blood draws. Question, when does the exigent circumstances exception justify warrantless blood draws? And the answer, the bottom line up front here, is that when the suspect's condition deprives police of a reasonable opportunity to get a breath test. So this is Gerald Mitchell. He lived in Sheboygan, Wisconsin, which is one of the funnest town names to say, Sheboygan. So,
Like West Chesterton Fieldville?
yes. So Sheboygan police got a call that a very drunk Mitchell drove off in a van. Police found him wandering near a lake, shirtless, wet, covered in sand, stumbling and slurring his words. So he's pretty far gone, right? Performing field sobriety test, police found, quote, hopeless, if not dangerous. And the portable PBT showed a BAC of 0.24. So they drove him to the station to go do an intoxilizer on this one. Try to figure out just exactly how drunk he was. On the way, basically, Mitchell passed out in the car, so they took him to the hospital for a blood draw, and they had to wheel him in there because he was just out. The officer, so I see this as kind of a comedic scene. He's passed out in the wheelchair as they're taking him into the hospital, and the officer is reading him the standard consent warning. And Mitchell didn't respond. He didn't say anything. So they drew his blood, which was a 0.22, by the way. So no surprise, he moves to suppress the blood test, saying that the police should have gotten a warrant for it. And the state courts rejected his claim. Some background on what the law is in this area. We've got 4 cases. Birchfield v. North Dakota was fairly recent, just a few years ago here. Search incident to arrest, they said, justifies alcohol breath tests without warrants on conscious people. So we have a blood draw here on an unconscious person, but we know that there are circumstances under which you don't need a warrant to try and get a measurement of BAC from somebody. Schmerber v. California, back in the 60s, the court said there that you can do a warrantless blood draw if there's an accident and there's no time to get a warrant. South Dakota v. Neville, back in the early 80s, prosecutors can argue consciousness of guilt from refusal to take a BAC test. And Missouri v. McNeely, the evanescence of BAC evidence alone is not enough to constitute an exigency. So the question in this case, is a suspect passing out a car akin to a car crash? So is this more like Schmerber, or is it more like McNeely?
So we talked about how fun Sheboygan is to say, but we're just going to gloss right over Schmerber like it wasn't even there.
Yes.
All right.
Yes, we are. When it's your case, you can talk about it.
Fair enough.
So the lower courts had split on this. They said in the state court here in Wisconsin, first in Sheboygan District Court, of course, that because Mitchell was unconscious, he couldn't revoke his implied consent under state law, which just about everybody has, including us here in Utah, right? So the question that he sought review on was, does a statute authorizing a blood draw from an unconscious motorist, this is a quote from his cert petition, provide an exception to the Fourth Amendment warrant requirement? So when the court granted cert, the U.S. Supreme Court is usually very, very careful about the questions that they grant cert on, and they take them as they are written. They don't rewrite cert questions. So everybody thought the court granted cert here to address the validity of implied consent laws. We're finally going to get an answer to this question, right? Whether the state can just say, you're going to drive on our roads, that's consent. Not so fast, says Justice Alito. Let's talk about exigent circumstances, which nobody had brought up. Yeah, so Alito's is actually a plurality opinion because Thomas concurred in the result only, but it's the most that we have in this area, so that's what we're going to go for today. So he says this is more like Schmerber,
Thank you.
you're welcome, than McNeely. In fact, unconsciousness, he says, is actually often more serious than a car crash. There are a lot of people who get in car crashes and don't suffer very serious injuries. But if somebody's passed out, that can be a lot more serious than tweaking your neck in a car crash. It's an emergency, he says, in and of itself. Incidentally, if you read Justice Thomas's opinion, he just says, let's just have a bright line rule and say there's no exceptions to it, because the plurality actually ultimately gets to, this is you can almost always do this, but not always. They say we don't rule out the possibility that in an unusual case, a defendant would be able to show that his blood would not have been drawn if police had not been seeking BAC information, and that police could not have reasonably judged that a warrant application would interfere with other pressing needs or duties. So anytime you have one of these cases, prepare for an argument that theirs is the exceptional case. I imagine every case for the defense bar is going to be the exceptional case. But it is helpful, and like I say, even though it's a plurality, the reasoning is good. So that's something to take a look at if you've got a warrantless blood draw.
Okay. Let's talk about probation and what happens when people are on probation.
You blew it!
That's been my experience. So, the question here is, does the Justice Reinvestment Act or initiative prevent a court from revoking probation based on a whole bunch of drug offenses and nothing more serious than that? The answer is no. The trial court, the district court, always has discretion to revoke probation if there's a violation. So here's another one. This is the only other one where I'm actually going to read the facts as written from the case. So I apologize, but sometimes when they're good, they're good.
Did Judge Mortensen?
I'm
trying to remember. Anyway.
I can't remember. It might be.
He's
We'll find out in a minute.
He's a very good writer.
Yeah. At least since 2012, Jordan Keith Hutchinson has had a drug problem. He pled guilty to his first drug-related offense in 2013 and then spent the next 5 years on probation, during which time Hutchinson was given the opportunity to participate in drug court and several other addiction treatment programs. None seemed to work, though, and Hutchinson racked up 24 probation violations, including the commission of several new drug offenses, even 2 for distribution. By 2018, the district court had seen enough and revoked Hutchinson's probation and imposed his original prison sentences. So, Mr. Hutchinson argues a couple of things. Number one, that the decision to revoke was in error, and he basically says there were two reasons it was in error. One, he says legally that the judge misapplied our current statutory scheme in light of JRI. And then factually, he says prison is too harsh. It's too mean for somebody who just has an addiction and a drug problem. And then the other main point he makes is that the district court did not make adequate findings in support of his ultimate conclusion to revoke probation. He didn't specify which violations he was basing it on. He didn't address all of the alleged violations that were before him, so he's saying the factual findings were insufficient. So let's talk about the statutory scheme for a second. Oh, sorry. This was actually Judge Ryan Harris who wrote the opinion for the court, but that's not Ryan Harris. Everybody knows that's John Cena. That's Ryan Harris. So, JRI, the statutory scheme, Judge Harris notes that significantly the amendments that were made to our statutes under JRI preserve the district court's authority to completely revoke probation. In order to require the court to apply the graduated sanctions, two conditions have to be met. Number one, the court has to impose a period of incarceration, and the court has to not revoke probation and impose the original sentence. As Judge Harris points out, neither of those conditions is met here. The court did not give him a specific period of incarceration, and he did revoke his probation and impose the original sentence. So, under those circumstances, he is allowed, or he doesn't have to apply the graduated sanctions. As to the argument that the punishment was overly harsh based on the fact that these are relatively minor violations, Judge Harris points out that the revocation of probation is well within the discretion of the trial court. Courts have wide latitude, and it requires an abuse of discretion for a court to look at that and overturn a revocation of probation. And that only occurs if there is either no reasonable person would have done it, or it's clearly excessive or inherently unfair or exceeds the statutory or constitutional limits. He also notes that even a single violation can be legally sufficient to revoke somebody's probation. Here, the court points out that the trial court did not revoke for a single or for a minor violation. He says over the period of these years, he racked up 24 violations, including what he referred to as 3 fresh ones, and that some of them were anything but minor. Ultimately, the district court gave Hutchinson every opportunity to comply and to succeed on his probation, and he did not take advantage of those opportunities. Therefore, when he violated, the court did not abuse its discretion in terminating probation, in revoking probation, and imposing the original statutory sentence. As to the factual findings that Hutchinson argues the court should have made, Hutchinson says the record needs to be clear as to specifically what the court was relying on, which violations he was relying on in revoking, and also noted that there were a couple of allegations that the court didn't address in his findings. This is an unpreserved argument, so he's going to have to show plain error if he wants to prevail on it. The appellate court here basically says there were plenty of violations to go around, so there's no harm in him not addressing a couple of them or specifying which one, because, and it looks like you guys may not be able to see this bottom line on this slide, but what he says is that it's entirely appropriate for a court to rest its decision on the totality of a probationer's supervision history as opposed to the most recent or any particular violation. So, the holdings of the court in this case were that he has failed to show that there was any error as far as what's demanded by the statutory scheme in revoking, because the conditions for having to apply the graduated sanctions were not met. Also, he has failed to demonstrate plain error as to the court's specific factual findings in ruling on the revocation. So he affirms. And this is a fail within a fail for your enjoyment.
Okay then. On to Kansas v. Glover. This is an important case on reasonable suspicion and revoked licenses. So I imagine this will be of particular interest to municipal prosecutors, but certainly not just to them. Question in this case, absent obvious contrary information, do police officers have reasonable suspicion to pull over a car if the owner's license is revoked? And the answer is yes. So here is on the left, Charles Glover, and on the right is deputy, according to Facebook, this sheriff's department has a Facebook page. Now lieutenant, according to the Douglas County Sheriff's Office, is Mark Mehrer, M-E-H-R-E-R, I don't know how to say that, we'll say Mehrer. They met on the mean streets of Douglas County, Kansas. That's probably the one street in Douglas County, Kansas, I don't know. So Deputy Mehrer saw a 95 Chevy truck tooling down the road. He runs the plate, learns that the owner's, who is Glover, his license has been revoked, and he pulled the truck over, and what do you know, Glover was driving. Glover moved to suppress, saying that the officer lacked reasonable suspicion, and the Kansas courts were all over the place on this one. So the district court granted the motion to suppress. The Court of Appeals reversed, saying it was reasonable to infer that the driver was the owner, or the owner was the driver. And the Kansas Supreme Court reversed again, saying this was only a hunch based on a stack of assumptions that the owner was likely the driver and that he was likely to disregard his license suspension, because we know that never happens, right? Nobody ever drives on a suspended or revoked license. They just patiently wait things out and ride the bus.
That's why the coffers of our justice courts remain empty.
So the Supreme Court, U.S. Supreme Court grants review and reverses to bring some clarity to all of this. So Justice Thomas writes the majority opinion, and he starts with reasonable suspicion. Says, look, here's the definition of reasonable suspicion. I have one up there from U.S. v. Cortez. It's more than a hunch, but it's less than a preponderance and certainly less than probable cause. This is one of those things, we've heard this song before. It's hard to articulate, but it's easy to spot once you've had a little bit of practice on this. Kind of brings to mind Justice Stewart's old saying about pornography. You know, you just kind of know reasonable suspicion when you see it. So if you're a brand new prosecutor and you're still kind of struggling with exactly what it means or having a hard time articulating it, you're not alone. We've all been there. You just kind of get a feel for it. The more you see it, the more you understand. But it's a very factual, practical consideration like this of everyday life on which reasonable and prudent men act, and something that's cut off there at the bottom. It permits common sense judgments and inferences about human behavior. So it comes down to probabilities or common sense, right? Now, there were a couple of amicus briefs in this case that took an interesting approach. They actually provided a bunch of specific statistics on whether people who owned their cars drove them most of the time and whether those things differed over the course of the country, right? Like, this had the potential to be really, really complicated. I suppose it would also vary from jurisdiction to jurisdiction if they started going down that road. But thankfully, the court didn't go there. They just kind of kept this at the general level of what we all know, common sense, right? Doesn't go down that rabbit hole. It's reasonable and common sense to believe that the owner is driving their car. And by the way, Justice Thomas says this is particularly true in Kansas, where most reasons for suspending licenses deal with traffic offenses, such as priors for driving on suspension. And he and the rest of the court didn't think it matters that sometimes people drive cars they don't own, or sometimes a license is suspended. The owner's license is suspended and somebody else is driving their car. There's no specific, and it doesn't matter that there's no specific law enforcement training or experience that imparts this knowledge, because that's something the dissent really glommed onto. But basically it's like, look, reasonable suspicion is not about certainty. You can be wrong. It's just, is there a factual basis to think that maybe somebody's doing something wrong, right? That's kind of what it comes down to. And the court just says, of course, if an owner's driver's license is suspended and you see and their car's out on the road, it's reasonable to believe that they're the ones driving their car. But there is an exception here. The presence of additional facts might dispel reasonable suspicion, says the court. So if the owner is a man but the cop sees a woman driving, that's going to dispel that reasonable suspicion. If the owner is old but a cop sees a young person driving, all that sort of thing, right? So if you see Steve Buscemi walking down the hall, yeah, odds are he's probably not a student there. You get the idea. So if you actually get a decent look at the driver and you know what the driver looks like or the owner looks like and that's not them, that could be a different situation. But absent that information, if you're just doing the usual as officers, just kind of pulling behind somebody, running the plate, seeing the information about the owner, you can have reasonable suspicion that they're the ones driving.
Okay. We're going to talk about conflicts, actual conflicts of interest. In this case, the question is, if an actual conflict of interest exists with counsel, that is to say that counsel represents two co-defendants in the same case, do we have to show prejudice to determine that trial counsel was ineffective? And the answer to that is nope. Whoops. So, in this case, the defendant, Mr. Tirado, was part of a fairly elaborate drug sting, and he got arrested along with his cousin. The two of them were both involved in this situation and this drug dealing. And then both of them ended up with the same appointed public defender, despite the fact that there were some fairly obvious conflicts in their representation. Cousin pled guilty, acknowledged his involvement in the case, and was not going to testify at the trial against Tirado. And so the state was proposing to introduce Cousin's admission or partial admission at the time of his arrest as part of their case in chief. So this was went up on appeal initially and then got remanded back down to the trial court to make a couple of determinations. One, if there was in fact an actual conflict of interest with trial counsel representing both Cousin and Mr. Tirado. And then secondly, if it was constitutionally ineffective, if his representation of Mr. Tirado ended up being constitutionally ineffective as a result of that potential conflict. So, in other words, they asked the trial court to just do the entire analysis and do their jobs for them, which is interesting because usually 23B is more of a factual thing, isn't it?
That's entirely what it is.
Yeah, that's what I thought. But they asked him to
Pretty
just do the analysis. Just let us know if there was a conflict and if it was constitutionally ineffective. So, after an evidentiary hearing, the trial court made some findings. First of all, that the two of them had been arrested together and that the cousin actually was willing to testify on behalf of Mr. Tirado. And then secondly, that there was in fact an actual conflict in counsel's representation, said that he was materially limited based on his responsibilities to Cousin, that Cousin's plea and his admission had actually undermined Tirado's defense, that he couldn't call Cousin as a witness without violating his duties to Cousin, and that he might be forced to actually cross-examine Cousin as part of it, which would, again, cause him to run into these inherently divided loyalties, and that this decision to stay on and represent both these individuals was prejudicial and not strategic. Or sorry, that the not objecting to the hearsay was prejudicial and not strategic. Okay. So this case was presided over by Judge Michelle. Is it Christensen or Christiansen?
It's neither. She's now...
Well, Forster, but isn't it all of it? Isn't it Christiansen, Forster?
Her married name was Christiansen, and then when she got divorced, she started pronouncing it Christensen. And now she's married again, and she goes by Christensen Forster.
Christensen Forster. Okay. So Judge Christensen Forster was the one who presided over this, but that's, I mean, as I'm sure you've learned by now, that's not who that is. That's actually Judy Greer, who you may know from such films as 13 Going on 30, Jurassic World, and one of my personal favorites, Arrested Development. There's Judge Christensen Forster. Under the Sixth Amendment, the analyzing an attorney's actions is a little bit different than it is under a traditional ineffective assistance claim. The court considers the following. One, whether the acts or actions that were allegedly omitted would likely have been made by other counsel. And then two, is there a tactical reason for the omission? Which sounds kind of like Strickland, but it's actually a little bit different, because in this they have to show that there actually was a tactical reason for which counsel took the action they took, as opposed to in Strickland, where we just have to come up with some conceivable reason that could have possibly been a strategic basis for what they did, but we don't have to show that that was the reason. So it's a little bit different standard.
I'm going to jump in just really quickly.
Okay.
And Scott and Ray gets rid of that conceivable tactical basis. We don't actually have to articulate a conceivable tactical basis. They have to rebut the presumption that it was reasonable. And
Yes.
so be a little careful on that. I mean, if you can come up with a good reason for why counsel did something, odds are you're going to win, and that's fine. But to think that the burden is on the prosecution to show that defense counsel had a good reason for doing what they did, that's not the case.
Well, but I mean, in Scott and Ray, though, it seems like if you can show a tactical reason, a conceivable tactical reason, you're still that's a big step in the right direction.
Sure, it's great if you have it, but
Yeah.
if you can't, it doesn't mean you lose.
Right. Yeah, it's not the end of the analysis, and we'll get there when we talk about Scott and Ray. Thanks for jumping ahead, John. Okay, so
It's called a teaser.
it is. No, it is that. Man, you're so good at this. The state argued that counsel's decisions were strategic for a couple of reasons. One, Cousin had some credibility issues. So for Mr. Tirado to associate himself with Cousin by having him come and testify for him might actually end up being poor strategy, might make him look worse. And then also, the state's arguing that the admission of the statement made by Cousin at the time of his arrest, acknowledging that some of this happened, ended up being superfluous to the fact that his conviction for that crime came into evidence, which included his admission. And so the state's basically saying we got it in anyway, so it doesn't matter that it also came in by way of his statement. The court, however, disagreed with the state on this one. The court said that unhampered counsel would have handled this case differently. Although there was already an association between Cousin and Tirado, there was already an association there. And so having him testify wasn't going to necessarily change that. But the potentially exculpatory testimony from Cousin outweighed any danger in him being even more associated in the minds of the jurors, because he was going to testify and say that it was all him and that Tirado didn't know what was going on, that he had nothing to do with it, that he wasn't a participant in what had happened. Having found that that counsel acted in violation of the Sixth Amendment, they don't even look at harmlessness, because prejudice is assumed under these circumstances. When there's an actual conflict of interest with counsel, then they assume prejudice, and so we don't even have to do the harmlessness analysis. So the holding here is that because an attorney not representing both of these individuals would likely have called Cousin to testify and would likely have objected to the hearsay statement, there is an actual conflict of interest in this case, and prejudice is assumed. So this one got reversed and remanded.
Being an appellate attorney makes me a pedant, so I'm going to nitpick for just one moment here. I wouldn't say there's no harmlessness. It's just a different kind of harmlessness analysis. So to show a violation of one of these actual conflict cases, you have to show basically they had a motive to do something against their client's interest, and they actually did something against their client's interest. So you have to have the motive and actually doing something. And the harm in that is you had an attorney who was not acting out of your best interests. When the court, or when Lance says that harmlessness is presumed, what they're saying is we're not going to look at whether this would have affected the ultimate outcome, because the violation wasn't necessarily the right to a fair trial. What you were deprived of was your right to counsel who was loyal to your interests. So it's just a different prejudice inquiry rather than a non-prejudice inquiry, if you want to think about it that way. That's something that helps me think about those cases. All right, very quick. Ramos v. Louisiana, a case about non-unanimous jury verdicts, which only really affected Louisiana and Oregon, and not even Louisiana anymore, because Louisiana undid that in their state constitution a couple of years ago, or last year or something, very recently. And Oregon was looking to get rid of it by the time this case rolled around. So you might wonder why in the world we would cover this, and I will tell you why. So the question, does the Sixth Amendment require states to have unanimous verdicts in criminal cases? Yes, it does, even though it didn't a few weeks ago. So you're probably asking, why should I care, right? Only 2 states, and incidentally, Puerto Rico, allow non-unanimous verdicts. So this doesn't affect how we do business. Why do we care? Well, I'll tell you. So this, do you know who this is, Lance?
No.
That is our friend William Blackstone,
Of course it
the
is.
great expositor of the common law. And I think I actually heard Steve Garside from Layton City say that. Good job. Bonus points for you, for our one attendee today. So according to his very famous treatise on the common law, which incidentally he wrote right around the time of the American Revolution, I think it was either published right before or right after the American Revolution. I want to say, anyway, right around that time in the 1770s. The common law felony prosecution had several aspects. There were differences for misdemeanors and petty crimes going back actually to the reign of King Henry II again. But if you were going to be prosecuted for a felony at common law, that had 3 things to it. You had to be indicted by a grand jury. You were judged by a panel of 12 jurors, and the verdict had to be unanimous. So these were the common law requirements for a valid felony conviction. So Ramos argued, and the court agreed, that when the Sixth Amendment said jury trial, it took all of this common law unanimity baggage with it. But if that's true, then that means the Sixth Amendment might also require grand jury indictment instead of filing informations and having preliminary hearings, and 12-person juries for every felony case rather than 8-person juries for most felonies. We only have 12-person juries in Utah for death penalty cases. So my office, me and our Solicitor General, Tyler Green, filed an amicus brief on Louisiana's behalf here, and we dug into I took a really deep dive into this thing and found examples of non-unanimous verdicts and said this actually, based on the drafting history, scant though it is, of the Sixth Amendment, actually they didn't intend them to be unanimous. The U.S. Supreme Court didn't agree with us. But Ramos isn't so important for what it held here, which is not too much of a surprise, but what it might portend for the future. Because if the U.S. Supreme Court said every state has to now have grand juries, and every state has to, in felony cases, and every state also has to have jurors, 12 jurors on each jury panel, that could significantly change the way we do business here in Utah, increase costs, all sorts of things. So we're looking for the next case that argues this. I don't think the current composition of the court would be inclined to upend things that much, but who knows? So we saw this as a slippery slope, which is why we put our or in, but we'll see where it goes from here, but something to be aware of.
Okay. Another Supreme Court case here, and we'll enjoy some Seinfeld real quick.
Was that wrong? Should I not have done that? I tell you, I gotta plead ignorance on this thing, because if anyone had said anything to me at all when I first started here that sort of thing was frowned upon, because I've worked in a lot of offices, and I tell you, people do that all the time.
So the question here is, it's about mental illness, and specifically mental illness that affects a person not in their ability to understand their actions or to understand the gravity of their actions, but to understand the concept of right from wrong. And the question is, does the Due Process Clause of the federal Constitution require a mental illness defense that acknowledges someone's inability to tell right from wrong? And the answer is no, it doesn't. And this is lengthy, so we're going to bust through it. So Mr. Kaler's wife filed for divorce in 2009. She moved out. He went over to where she was staying, and he shot her, her mother, and his 2 daughters. He let his son live and ultimately surrendered and was charged with capital murder. So there was a motion that he filed before the trial court essentially saying that Kansas's insanity defense statute, which is remarkably similar to our insanity defense statute, violates due process because it essentially abolishes the defense of insanity, because it doesn't account for someone's inability to be able to distinguish right from wrong. The trial court disagreed and denied the motion. He was ultimately convicted, but he was allowed to then present the mental health evidence that he had wanted to present as part of his trial in preparation for sentencing as mitigation evidence. And nevertheless, the jury ultimately still sentenced him to death. So at the Kansas Supreme Court, Mr. Kaler made the same argument that he's making here on appeal. And that court relied on its earlier precedent to say that there's no single version of insanity defense that's required under the Constitution in order to be what's referred to as fundamental. The Due Process Clause does not mandate a specific insanity test. On appeal, and the appeal here was handled by Justice Elena Kagan, but that's not Justice Kagan, that's Kevin James. That's Justice Kagan. The same issue was raised, and basically asking if the Due Process Clause requires an insanity defense that would acquit somebody based on their inability to distinguish right from wrong. Cert was granted on that issue, and that is this case. So, some background. The court walks us through some insanity defenses among the various states and found there to be basically 4 primary strains of insanity defense. Number 1 is cognitive capacity, and that is someone's ability to understand their actions, to understand what they're doing. The second is moral capacity, and that's someone's ability to understand the wrongness of their action. And that's the thing that Kaler says is lacking in Kansas's insanity defense statute. What they have is essentially the first one. If it defeats mens rea, then it's a defense. But if it doesn't, then it's not. There was a subsequent spinoff to moral capacity saying not so much that it was wrong, but that it was illegal. But that's not one of the main 4 that she talks about. Those first 2, cognitive capacity and moral capacity together, both understanding what your actions are and understanding the rightness or wrongness of your actions, are what they refer to as the McNaughton test. There is also volitional capacity, which is essentially that because of mental illness, somebody had an impulse that was so strong they were unable to resist it. And then the product of mental illness category, where essentially because somebody has a mental illness, if the offense arose out of that mental illness, if it's a product of it, then that's a complete defense. So Kansas's law, it shall be a defense to a prosecution under any statute that the defendant, as a result of a mental disease or defect, lacked the culpable mental state required as an element of the offense charge. So again, if the mental illness prevents them from having the requisite mens rea to commit the offense, then it is a defense. But it specifically says that any other mental disease or defect is not otherwise a defense. Again, this is the cognitive capacity. This is the first or the second. This is half of the McNaughton test. And then under Kansas's law also, they have wide latitude to present that evidence as mitigation at sentencing. It's not just the fact that this was a capital case. In any case, they have that ability. So the analysis from the court. Due process is only violated if the particular principle that it offends is considered to be one that's fundamental. And the court looks to historical practice, to eminent common law authorities and early judicial decisions in doing this analysis to try to decide whether or not this principle that Mr. Kaler says was violated is a fundamental principle. She said that an affirmative answer to that question is rare, though not unheard of. And because normally criminal responsibilities and these kind of issues tend to be the province of the state, and the federal government tends to want to sort of stay out of that arena and not necessarily second guess what a state does on this. She says that is particularly true of insanity, where there is a lot of uncertainty in that area of science, in that area of medicine. There's just a lot of uncertainty as to what's going on in a person's mind. And she feels that it would be indefensible for this court to come in and impose a particular single test. She agrees with Mr. Kaler that for hundreds of years, the concept of insanity has relieved people of criminal responsibility. She disagrees with him, however, that Kansas's statute abolishes that precedent, that it does away with recognition of insanity as relieving somebody of criminal responsibility. It just does it in a way that's different than what he would have liked. So the holding here, Kansas's statute takes account of mental health both at trial and at sentencing, and the court feels that the specifics of exactly what that defense is or what it entails or what it's based on is something that should be Kansas's decision to make, and she says to remake and remake again if need be, but that's really the province of the state to do so. So this was affirmed. But before you think that we're going to take an 11:15 break, we're going to take an 11:17 break because there was a dissent, of course, and this was Justice Stephen Breyer who did the. Oh, that's not Justice Breyer either. That's Henry B. Eyring of the Quorum of the 12 Apostles. Okay, that's Justice Breyer. And what he said was that Kansas has eliminated the core of the self-defense, that it has existed for centuries, and they just did away with it because if somebody lacks the capacity for their conduct to be blameworthy, then there shouldn't be criminal responsibility. And he says this does, in fact, offend a principle that is fundamental. So he gives an example, which is interesting. He says you got two similar prosecutions for murder. In one case, you have somebody who thought the victim was a dog and killed the dog. In another case, you have somebody who thought that a dog told them to kill the victim, and they did. He says under the traditional insanity defense, which is the McNaughton, the cognitive and moral responsibility defense, neither of those people could be convicted. But under Kansas's law, you could convict the second person, but not the first, and that's what he takes issue with. So he says he's not saying McNaughton is constitutionally required, although he kind of is. He says really McNaughton is just a broader way of describing, or a more specific way of describing a broader fundamental principle, and that is that that mental illness is, well, and I was just going to read the quote, may so impair a person's mental capabilities as to render him no more responsible for his actions than a young child or a wild animal. So he says that, and he kind of argues back and forth in his own dissent. They do this a lot in their dissents. He argues back and forth with the majority. They say that there's so much diversity in what exists at the state level that you could never actually have any kind of a consensus, but he disagrees with that. He cites to a bunch of also historical sources, and the majority accuses him of cherry picking some of that discussion, some of the things discussing intent and mens rea. And he says, well, the modern understanding of mens rea is very different than the historical definition of mens rea. Historically, there is a principle of moral responsibility as a standard implied in an insanity defense that he thinks has been lost. So he also says with respect to McNaughton that to the extent states have broken away from McNaughton, they've done so because they thought it was too restrictive, not too broad. And that's why they've landed on the product test, where anything that is a product of a mental illness is going to be a basis for a defense. He pointed out that 45 states, the feds and DC, all use the McNaughton test, and that a community's moral code has to inform its criminal law, and that the farther those get apart from one another, then the more we have a problem. So he says, although there is broad leeway for states to fashion their own insanity defenses, it's not a blank check, and he feels that Kansas did away with something fundamental here. So he dissents, but the ruling, or the majority opinion, still stands here.
Yes, and thank goodness. And one quick shout out, Drew Peterson from our office actually did an amicus brief on behalf of Utah and several other states. And this was a very good result for us, because this all changed because a guy named John Hinckley shot President Reagan back in the 80s, and people were upset that he would get off under the traditional McNaughton test. So that's why we have the test that we have, and why Kansas has the test they have. So fortunately, the Constitution permits that, and looks like it's time for a break. Back at 11:30, 11 minutes, I guess.